thank you very much for that intro, and thank you to the organizers for having me here to give a talk. I'm a big fan of the PETs community. I've been to the PETs conference a few times now, and I think it's one of the key conferences for also for legal people to follow to see what's happening in terms of privacy technology development and discovering of new technical privacy issues. So it's a big honor to be here. I'll be giving a talk about the GDPR. The GDPR that I guess who hasn't heard of the GDPR in this room? It's basically no one. So yeah, this has been quite a ride, especially the last months with it entering into force. So I'm gonna try and do as good of a job as I can of telling you something about the GDPR in a way that I think would be interesting for your community. So let's hope that I'll manage at that. So yeah, I'm a professor of law at the Vrije Universiteit Brussels. I was there appointed to the chair of Fundamental Rights in the Digital Transformation in last fall, which is a new chair that is established at the LSTS group, that is the group that organizes the CPDP conference that many of you may know, and it was established with the support of Microsoft. That is a part-time position. For the other 50% of my time, I'm at the University of Amsterdam at the Institute for Information Law, where I also did my PhD research on search engines and freedom of expression. So as just a quick overview of what I want to do with my talk. First, I think it's important to talk a little bit about the basics of EU data protection, put the GDPR into context, and hopefully clarify that a little bit more. It's like what place in the legal landscape, in the European legal landscape, the GDPR has, and then also speak a little bit about what are the main legal ingredients of what is in the GDPR. So then I want to focus on what are really the important changes in data protection that have been introduced by the GDPR, and there I will obviously also focus on some of the things that I find most interesting, and also some of the things that I think are most relevant from a PETs perspective. Then I will talk about some developments in enforcement and compliance. So the GDPR has really changed the enforcement and compliance context quite a bit. There's a lot more pressure, and things are moving in a particular direction. And there's some interesting things also to be said about civil society action that I want to talk about. And then we'll move on to some perspectives on PETs and the GDPR. So on the EU data protection basics, yeah, I ran into this very funny report about an app that actually, so this is one of those mindfulness or relaxation apps, and one of the things you can do is listen to the GDPR. It's actually a BBC News reader that reads the content of the GDPR. And I think there's something going on here, of course, that is these app developers, they run into the GDPR, they have to do something with the GDPR, and I think there's something of kind of poking at it and not being too happy about it. But I think it's also the fact that the news picked up on it like this and just make it seem that it's something very boring. There is actually, if you read it carefully, there's quite some very exciting things that you may run into and that you could use also as a basis for research, including technical research, or all sorts of campaigns that you could do. So I think it's a bit of an overstatement that you would fall asleep. If you would really read this with an interested mind, you may actually lighten up a little bit. So, on the basics. So national data protection laws, they exist in Europe since the 1970s. Hessen, a part of Germany, Sweden, France adopted data protection laws already in the 70s. Then after this, there was development of international data protection standards, for instance, in the Council of Europe context, in what is called Convention 108, which was also recently amended. A new version was adopted. This originally was adopted in 1981, and also in the OECD, which is an international organization that includes the United States, principles were adopted in the 1980s. So EU level data protection already exists since 1995. And in 1995, the member states acted to harmonize all the national data protection laws in the interest of the internal market, so there could be the free flow of personal data within the European context. So this harmonization exercise resulted in the Data Protection Directive. A lot of what is in the directive is still there in the GDPR. Actually, the GDPR leaves a lot of the directive unchanged. And I think this is very important to realize, that it is not that we suddenly have this whole new law with all sorts of new principles. That is really not the case. So, and then very importantly, the right to protection of personal data was codified as what is called a fundamental right in Article 8 of the EU Charter of Fundamental Rights. So like for US people here, this is like, for Europe, this is like the Bill of Rights. You know, this is like, these are specific provisions, constitutional status, fundamental rights. So it's really the protection of personal data is elevated in the legal domain to this fundamental rights status. This first was declared, solemnly declared. It wasn't binding yet in 2000, but it then became binding since 2009. And that's a very important element of European data protection law. So I put that, because it's so important, I put it on a slide. So Article 8, protection of personal data. So this is a separate right from Article 7, the right to protection of private life. It also includes the protection of confidentiality of communications. But now we have this separate right on the protection of personal data, and it says quite generally that everyone has the right to protection of personal data concerning him or her. That is in relation to government processing of personal data, but it's also in relation to private sector, which is quite important. You call that horizontal effect legally. And such data must be processed fairly, for specified purposes, and on the basis of the consent of the person concerned, or some other legitimate basis laid down by law. Everyone has also the right of access to data which has been collected concerning him or her, and the right to have it rectified. So here you basically, some of the elements that you have in data protection law have been put into the fundamental right and just elevated to this higher legal status. And then additionally, in the third section, compliance with the rules shall be subject to control by an independent regulatory authority. So the independent oversight is also part of the fundamental right. But what does it really mean for protection of personal data to be recognized as a fundamental right? So I think one of the ways in which you can see really the implications of this is what the Court of Justice of the European Union has done over the last years in a number of really far-reaching rulings that really strengthen the right to privacy and the right to protection of personal data in the European Union. So first of all, the Digital Rights Ireland case from 2014, which resulted out of strategic litigation from civil society against the Data Retention Directive. The Data Retention Directive, which was adopted in 2006, that had to do with, like, that made it mandatory to store the electronic communications records of people using electronic communication networks. So this is a very, like, widely debated and contested directive because of its wide privacy implications for people using electronic communications networks. And this litigation was in the end successful, but the Court of Justice said this directive really goes against, like, the fundamental rights to the protection of private life and also protection of personal data, and annulled the directive. And so as a result of that, we don't have EU-wide data retention. There are still a lot of countries that are trying to pass new laws. There's a lot of pressure to have some form of data retention, but we don't have it anymore. So then the Google Spain and Costeja case, also known as the right to be forgotten ruling, which resulted in a ruling that said you have a right to request deletion of specific search engine results for name queries, so for people search, even to lawfully published information online. And so even though the information that can be found online is legally there, it could be so that you have a right for that information to be delisted from a search result in the situation, you know, that the results are presented on the basis of your name. You know, which is a very radical proposition. And the court developed that proposition based on the understanding that bringing all this information together in a search result page really had this potentially disproportionate impact on people's privacy and reputation. And they used data protection, very basic data protection principles, to ask for the correction of your data, to object to the processing of your personal data. General rights that have not been developed at all specifically for a search engine context, but they interpreted in this specific context as having this effect of allowing you to ask for that, and then developing some broad balancing principles in what situations you actually had to remove. So then on two basic, very fundamental notions of data protection, the court made quite sweeping rulings. First of all, in the Breyer case, Patrick Breyer from Germany, also an activist, he litigated on the status of dynamic IP addresses under data protection law. So the question is that still personal data? The court said yes. And then in a recent case, that is about Facebook fan page, an organization using that, the court interpreted the concept of controller, which is a concept that's basically the controller is the entity that is responsible for the rules under the directive or the GDPR, and really developed that very broadly. And so then one thing I want to highlight is what the court did is they came up with this standard to decide these cases on data protection and privacy, and they said it's basically the standard is that the protection should be complete and effective. And if you read some of those rulings, you see this standard actually being used like somewhat of a deus ex machina. If there is some kind of problem of interpretation, they always they use this standard to say, well, we can't have that interpretation because that would allow you to evade the protection. So then using this complete and effective protection standard to really have very, very strong rulings on the scope of data protection and also on its applications. So the EU General Data Protection Regulation, the GDPR, it was proposed in 2012 by the Commission under the responsibility of Viviane Reding. It was then adopted by the member states in the European Parliament. That's how it works with European legislation. It's debated between these entities. In 2016, and the rapporteur in the European Parliament was Jan Albrecht, who's a member of the Green Party. And then it entered into force just this May of this year. But there's a lot more data privacy and a lot of more data protection than the GDPR in Europe. First of all, there's, for instance, the Police Data Directive, which was adopted at the same time as the GDPR. So the GDPR is about commercial personal data processing and also public sector data processing, but not for specific part of the public sector. First of all, intelligence agencies, national security is completely outside of the scope. That has to do with the fact that the European Union doesn't have a competency in that area. And then for police, law enforcement, that's also out of scope, and there are separate rules for what police can do with personal data and how they can exchange it. So then secondly, and this is debated at the moment, there are the e-privacy rules. And these are actually rules that are quite relevant for this community because of a lot of focus on communication systems and internet tracking. So the proposals are currently under discussion for a revision of the e-privacy directive, making it into a regulation. And issues there include online tracking, Wi-Fi tracking, browser and OS privacy settings, confidentiality of communications, messaging services, and encryption. So then, in the area of law enforcement, lawful access to data, there are proposals that try to address cross-border issues in lawful access to cloud service data, and these are called the e-evidence proposals. They have just been issued by the European Commission and are under discussion. So the GDPR, in short, just to give you my quick kind of characterizations. So very shortly on the substance, the GDPR, it aims to ensure the fair, lawful and transparent processing of personal data by organizations operating in the EU or processing personal data of people residing in the EU. So you could be somewhere else, but you're focusing also in the EU as a market. And making that also subject to independent regulatory oversight. So that's really the general basics of it. So then what type of law is this? So it's comprehensive. It's an omnibus regulatory framework. You say, instead of having maybe a vertical approach where you say, we're going to regulate what is being done with personal data in the financial sector. We're going to do it in the health sector, in the educational sector, or what municipalities can do, like government services, and have specific rule sets and frameworks for those particular contexts that also present, of course, particular privacy issues and have particular types of systems that may be implemented. Instead, this is a very sweeping, general, comprehensive regulatory framework. And it stipulates broadly applicable, quite interrelated and general obligations and rights. And as a result of that, there's quite significant legal uncertainty about their appropriate interpretation in specific contexts. And so the rules are actually so broad that it takes a lot of work to know what exactly they mean when you apply them to a particular data processing operation. It's 88 pages, the GDPR, in what is called the official journal, so that's where the laws are being published, stipulating 99 articles and 173 recitals. Those recitals are, let's say, explanatory considerations. They give you a little bit more background of about the law and about the actual provisions. And the GDPR was adopted in a very heavily lobbied process in which more than 4,000 amendments were tabled. There's actually a documentary about the process that was made. So they're really quite, and this has surprised a lot of people that have been involved, policymakers, government officials, politicians, that the end result is really quite strong. So really relatively strong protections in the final text. And I don't think that for a lot of people why are proposals made? Why is there a GDPR? And it's there's not that much change in relation to the directive. And I think a lot of the people that really pushed, the political push to do a new version of data protection law at the EU level, the anticipation was not that it would suddenly become this super strong text. No, that was not the strategy of some of the powerful entities pushing for a new instrument. I have the sense that one of the main goals was actually to create a much more transatlantic personal data space to resolve some of the international issues and also to do something about the lack of harmonization. But as a result of quite a combination of events, Snowden revelations happened in the middle of this. Also the European Commissioner that was responsible really taking a very strong position on privacy and the importance of giving people control over their personal data. A very privacy-friendly rapporteur, that really pushed, he was from Germany. Generally, German politicians care quite a bit about data protection. And he worked also very closely with civil society. And there was very effective lobbying and campaigning, both by civil society. There's a website, lobby plaque, that detailed also some of the impacts that civil society had. As organizations like Bits of Freedom, European Digital Rights, Panopticon, they did a really good job in the beginning of influencing the process. But also the data protection authorities and the whole kind of official data protection community of regulators, they had a big influence. Okay. So that gives hopefully a little bit of context. Now talk a little bit about what is the substance. So GDPR is a law that is applicable to, this is really the core thing, processing of personal data. So personal data, that's really quite a broad concept. So this is any information relating to an identified or identifiable natural person. So the two basic, the really important part of this are this identified, identifiable. This community knows a lot about what are the boundaries of that, and how hard it is actually to have, once you have quite rich data sets, to prevent that data from using it to identify people. But the element relating to is also very important. This is not just information that is about people. This is also information that is in somehow way linked to a person because it, for instance, can affect that person. It's going to be used to evaluate that person. So this is a very, very broad concept. So then the thing is, if there is processing of personal data, processing is basically anything you can do with information. The question is, who is responsible? And the law has basically two key kind of entities. Conceptually, it's on the one hand, there's their controller. This is really the central one. The controller is the entity that determines the means and the purposes of the processing. And importantly, you can have multiple controllers doing this together. And then there are processors, and these are entities that are doing processing basically under the authority of the controller. So they're like basically asked to do something with data. For instance, in a human resources management context, they're being asked to do something with data because of administration, or and in the cloud context, there's a lot of processor activities. So then the question is, what are the main responsibilities? What are the main obligations for those controllers? So the first and probably the most fundamental legal requirement is that you have to have a legal ground for processing personal data. So, and one of the legal grounds that is most known and is most well known is the one of informed consent. Basically, a person was informed about what you're going to do with their data, with their personal data, and then said, yes, I'm okay with that. No, so that is consent, informed consent. But there are multiple other legal grounds, and in many ways they're maybe even more important. They're more objective legal grounds. So these are legal grounds is like this, it's necessary to do what the system is supposed to do. Or it's necessary because like we are the tax authority and we have to administer tax and tell people how much tax they should pay, and we should check it. So it's based on the fact that there's a law that gives us the authority to be a tax authority and to do this kind of work. Now, and the one that is very important too is the one of contract, which basically the processing of the personal data is necessary to offer you the services that you enjoy. So that has some, of course, similarities with consent, because the person is like agreeing to use the service, and that implies that there's personal data processing. So then finally there's a legal ground that's called the balancing provision, where you say, I have a legitimate interest in processing this personal data. For instance, I need to make my system secure, cybersecurity reasons, and the risks for the right and freedom of those whose data I'm processing, it doesn't outweigh my interest of personal data processing. So it's like it becomes a bit of a balancing exercise, and there are some specific legal implications of that, because people can say, actually in my specific individual case, I don't think that balancing exercise is in your favor, you should stop processing my personal data for this reason. So then, the purpose limitation principle, so this is also, you saw that in the fundamental right. So the idea is you only process personal data for limited, specific, and explicit purposes. And once you have determined those purposes, you can also do this legal ground lawfulness exercise and say, do I actually have a legal ground for this particular purpose? Then you have to be transparent about the processing. There's some specific much more strict rules actually for sensitive data. So these are personal data that reveal sensitive attributes. There's actually a lot of debate actually for decades, like how difficult it is to actually really say what is sensitive data and what is not sensitive data. And because of the predictive turn in computing, this has become much harder. So there's we can probably see a lot of debate in the coming years still about this particular type of rule. Then accountability. So this is the ability to demonstrate compliance. So the idea is if you're a controller and you're responsible for these things, it's not just that you have to look at that and decide I'm okay. No, you actually have to document the way in which you demonstrate for yourself, and then potentially if a regulator asks, that you're actually complying with the rules. So it requires all sorts of documentation and risk management, and also in the principle of accountability, data protection by design is included, which is a new thing. I'll talk about that a bit. Then there's international adequacy. So the idea there is that Europe, we are great, we have organized all these data protection rules. Now we have to prevent that this data leaking to places where the protections are not good. So that results in quite a lot of tension, obviously, with other countries, including the US. There was just now a new decision, I think, from the European Commission on Japan being adequate or not. And then there's another element which is important, are the data subject rights. So these are rights to give people, individuals, access to their personal data, the right to ask for correction when it's not correct, to object to their processing, to ask for erasure in particular cases, a new right to data portability, and some rights in relation to profiling and automated decision making. And then, as said, this is made subject to independent regulatory oversight. So these are national established data protection authorities, and they work together in what used to be called Article 29 Working Party, but it's now the European Data Protection Board. Okay, so these were the basics. Are there any questions at this point? Carmela.
What about proportionality?
What's that?
What about proportionality?
Yeah, so the proportionality is the proportionality as a principle. You see it mostly in the lawfulness. You know, so the question of, are you allowed to process? So for instance, like, then it's like, it's necessary to offer the service that I'm offering you, and there you have to do a proportionality exercise. But you can also maybe see it in some other areas where, you know, data subject rights, someone has access to their data. They say, well, there's, for this data, it's going to be disproportionate amount of work to really find all the data for you, so I can only give you this. You see, like in different areas, that proportionality can pop up.
So I've heard this GDPR referred to Act for Privacy Lawyers Act because your neighborhood tapas restaurant suddenly has to keep a privacy lawyer on staff to ensure that they're not violating some rule. Is that part of proportionality of expressing a reasonableness of the amount of work that a small organization needs to do? So that's my first question. And then my second question is, looking forward 5 years, what do you think courts and the public are going to react when they see how much effort goes into this in cases where the risk may not be very big, like this restaurant leaking their list of customers?
Those are great questions. So there's been quite a lot of debate about, like, of course, the cost of compliance on this, and it's true, and I will get back to that a little bit. It's like there's basically everybody is a controller. No, so and that every local shop, every local business, all sorts of organizations, they are basically controllers. We are also all controllers. Like, we are controllers for maybe the personal data that we post on social media. You know, like, for also probably for research that people are doing involving personal data processing. And so then the question is, like, is that really reasonable, and where should the focus really be? I think, like, in a lot of situations of organizations that are made, like, let's say a local shop, or like, and they're processing personal data of their personnel, more and more I think they're using not like unique information systems. You know, they're actually plugging themselves into a service environment where a lot of the compliance will have to just be baked into the services. So that solves some of the issues. You also, like, have the question, of course, do you really need to have a data protection officer? Yeah, so there are some guidelines, like there's the rule of, like, having a data protection officer as part of this accountability thing, and there you have some boundaries. If you don't do very large scale processing, or you're not systematically monitoring people, you don't have to give a DPO. But what you see is that the rules are actually they are a little bit on the broad side. So there's really a risk of over-regulating and really putting a lot of energy into regulating things that are really not that risky. So there, another thing that could help is what is introduced in the GDPR, is what is called a risk-based approach. Also, there's really, like, the idea is that you really go through this risk management exercise, and it could be that you just see, like, this is really not a big deal. But yeah, this definitely the question of, like, what is reasonable to expect from different types of controllers is an important one going forward.
So you mentioned that the GDPR is a little broad and little vague, like, and the way I see it is, like, the challenge of like formulating or drafting such laws for each specific case. It just becomes, because technology moves forward so much faster, I think, and so it becomes really hard to really have a policy for sort of each use case. And so how do you draw the balance between what should be a policy versus what should just be left out vague and open?
So this is a great question, and just to repeat it for everyone, the question is, like, how do you actually strike the right balance between formulating, like, on the one hand, like, you maybe want to be quite specific about what you require, so you would, like, want to maybe design very specific laws that are, like, really clear about what is required in a specific context, or where like and the obvious downside of that like things are changing all the time, and maybe like it's really important to actually have the rules on a much more general conceptual level. So I think the answer of the GDPR is that so this is like in theory how it should work, I think, is that you have those very high principles, and then practice, and these are the controllers in the first instance, they do the work of like interpreting these rules and then making themselves accountable for that interpretation, which of course still allows for pushback. That still allows you to say, you did a terrible job interpreting this rule because like you should have done this. So that is, and then what you have too is like you have this possibility of codes of conduct where you put some of those maybe domain-specific or sector-specific interpretations, you put them on paper and you say this is the way that we think the GDPR means for us.
Can you talk a little bit more about the consent requirement? Because if I understand correctly, it's more than just informed consent, but it has to be like willing or something like this, of saying like, I've heard that the GDPR might actually be prohibiting apps from, say, giving you the choice of you can give us your location or you could not use the app. And if the app has nothing to do with your location, that is not actually willing consent anymore, even if it is informed.
Yeah, so that's the element of the consent needs to be informed, but it actually also needs to be freely given. Right. So, and there you see a lot of developments, especially like in the tracking walls and things like that, where the question is actually, should you offer the service, like excluding those maybe more pervasive types of like surveillance that come with it. So should you have an option of like going to a newspaper website without like all like tons of trackers on them? And there's been a lot of debate, and this is actually one of the specific issues that the e-privacy regulation is like probably going to give some answer to. So in the GDPR, there's a general provision, and that says like that kind of extra emphasizes, it's Article 7.4, that consent should be freely given, and that also like it means that you're not allowed to bundle personal data processing with the offering of the service. So what you have to do is you split up that part. And so you're offering the service that has some basic personal data processing that is necessary for the service, and then for additional, let's say, features or things that are happening, you have to ask separately consent, and that's an opt-in. So, and there's a lot of debate about this. I'll come back to this. I'm gonna move on because otherwise there will be, I will run out of time too early. But maybe you can keep your question for the next interval. So I want to talk a little bit about notable changes. So first, and I mentioned this already, there's more harmonization. And one of the ways this happened is we moved from a directive to a regulation. The directives have to be implemented. Regulation is just directly applicable. But there's actually still a lot of flexibility remains, and especially that's the case in the public sector. In the whole regulatory process, all the political debate and focus was like all these tech companies and private sector and what is happening with our data, and actually not that much focus on what is happening in the public sector. That has a little bit to do with the relationship of the European Union institutions to the member states, and member states like they would prefer like that maybe not like to be scrutinized in that area as much, and they also, like they said, we just want quite a lot of flexibility there. So what we ended up with is actually still a lot of flexibility and what you could say a directive in disguise. So this is maybe interesting for lawyers, but I think it's an important thing. So then one very interesting, from a technical perspective, addition to the rules is this new concept of pseudonymous data. So it used to be the case that we have, on the one hand, we have personal data. I gave you the definition. So, and then we have data that is not personal data, so any kind of data, but also data that has been effectively made anonymous. But now we have this in-between form of personal data. It is still personal data, but it is data, the processing of personal data in such a manner that the personal data can no longer be attributed to a specific data subject without the use of additional information, and provided that such additional information is kept separately and is subject to technical and organizational measures to ensure that the personal data are not attributed to an identified or an identifiable natural person. So data that has gone through some process of de-identification. And apparently this is really key. You know, I'm hearing that this is very important in practice, and a lot of industry is relying also on this provision because it gives you, basically gives you a few like bonus cards. You know, it gives you some jokers to say, under this provision, for instance, are you allowed to use data for new purposes? But if you have pseudonymized the data, that gives you a little bit of a benefit there. I think, though, that this concept itself and how it really works and what it means to do pseudonymization in terms of like offering people privacy guarantees is something that still needs a lot of discussion. So then another element that changed, so there are rules about transparency, and basically you have to say all sorts of things that usually they're put in a privacy policy. What are you doing with people's personal data? What are you collecting? What are the purposes? Under what conditions? And so this is that you have to be now transparent about the legal grounds for processing personal data. And this is very important that it wasn't the case. And so it was always kind of strange, like situation where you had to kind of guess what is the theory under which the controller is processing your personal data. And now they have to be very explicit about that. So there are like notable changes on data subject rights. There's this right to be forgotten, which is like actually called the right to request erasure. So when there's no longer a legal ground for processing, you can request erasure of your data. There's a new data portability right, and just this week there was an announcement of some of the major tech companies working together in an open source platform to allow for this data portability right to work. Quite interesting also technical challenges there. The idea is to like let APIs talk to each other and like allow people to take their data from one service and move it to the next. So it also like relates kind of to competition between services. Then there's a right not to be subject to automated decision making with significant legal effect. That actually was there already, but there's been a lot of discussion, especially in relation to automated decision making, whether we actually now with the GDPR have some right to explanation, and there's some like hint at that, is like that people should get meaningful information about the logic of automated processing. But the real important change, I think, from the PETs perspective, is this introduction of what is called information accountability. This is from an article from 2006 by Danny Weitzner and others, where they said, this is like the headline, it's just a screenshot from the paper, with access control and encryption no longer capable of protecting privacy, laws and systems are needed that hold people accountable for the misuse of personal information, whether public or secret. So this is really giving up on PETs in some ways and saying we have to just do this other thing, which is just keeping track of information and being able to tell when something went wrong, whose fault it is and what happened. So the notable changes in the GDPR is that first there is this general responsibility to be able to demonstrate compliance. Then there's a data protection officer, which I just mentioned. So you have to appoint one if you're like public sector or large-scale personal data processing or systematic monitoring, which according to the regulators also includes like internet tracking. Then there's this risk-based approach to compliance and enforcement, and this risk-based approach, you see it most clearly in what is called a data protection impact assessment. And this data protection impact assessment, that is something you have to do in the case that there is a high risk for the rights and freedoms of individuals, and then you have to detail those risks and also detail all the organizational and technical measures that you have taken to mitigate those risks. And so it's like basically you go through some kind of compliance exercise there. And then there's the data protection by design and data protection by default standard. So it's really you have a general obligation to do data protection by design. So I mean that sounds very hopeful. The only thing is that if you look at the provision, the big problem is it's not really clear what it asks you to do. So this is the data protection by design standard. So taking into account, this is all sorts of considerations, like you have to look at this, you have to look at this, you have to look at this. Like the controller shall, both at the time of the determination of the means of processing and also when you're doing it, you have to implement appropriate technical and organizational measures, such as pseudonymization, so that's kind of singled out. That's something good to do, no? which are designed to implement data protection principles, such as data minimization, and you have to do that in a way that's effective, and then to integrate necessary safeguards into the processing in order to meet the requirements of this regulation and protect the rights of data subjects. So I mean, like, I'm not able to tell you what exactly this requires, and so there's a lot of questions like, what does it actually mean? I think another important question about this, who is actually responsible for doing this? You know, like, is that like this small scale shop that is a controller, they have to do data protection by design, they're not technical? No, so actually they're like, who are the ones that actually design systems? They're not actually directly regulated. No, the developers are not directly regulated under GDPR, they're often not the controllers. So then there's a recital, so one of those explanations that says like producers, they should be encouraged to take data protection into account and to basically design systems that help the controllers to be compliant with the GDPR. So this is like, just to be very clear, this is quite soft. This is like kind of hopeful that they will do, the developers will do this. So on enforcement and compliance, so it's really like, this is like, the action is really because it's really quite a strengthened regime on enforcement. So we have this information accountability that gives quite a push, but also the data subject rights that we made more explicit, strengthened in certain ways. There are much stronger oversight powers for regulatory authorities, including this possibility that has been widely reported to give really high fines up to a maximum of 4% of global turnover. Now that's enormous for some of the big tech companies, of course. There's this one-stop shop mechanism. Article 29 has been strengthened a little bit into the European Data Protection Board. There's increased coordination between the data protection authorities. There's all sorts of business-to-business activity too. You know, businesses scrutinizing each other on compliance in the processor controller area, but also between controllers. And then there's, and this I want to stress, there's enforcement not just through these regulators, not just regulators looking at what is the landscape and doing research and going after, like, no, there's a very strong track of pressure, enforcement pressure, coming out of individuals in civil society, using private right of actions, using this data subject rights, asking for what's going on with my data, I want to have access to it, you're not responding in the way that you should be responding. And a lot of this is actually directed at the courts. You know, it's like, so it's like really getting like interpretations that are favorable from a data protection perspective. And then we have this situation where also basically everybody can be considered a data controller. You know, so responsibility under the GDPR is really increasingly networked and complex. There's a very broad concept of what is a controller, and this ruling that I mentioned earlier really establishes, like, it's really a sweeping interpretation of what can be considered a controller, but also like, so this, even in the situation that you do not have access to the personal data, so and this was in the case, the Facebook fan page was considered a controller for the processing of the personal data by Facebook for audience analytics features that were offered to the owner of the fan page. But it's not even that fan page had actual access to those underlying data. But they caused the processing to happen. So, and I think this is a little bit my perspective on this. Is like, it's quite extreme. GDPR has become an instrument of quite unlimited information flow scrutiny. So this is a quote: "Everyone is guilty of something or has something to conceal. All one has to do is to look hard enough to find out what it is. Each organization, permanently aware of its own reliance on personal information architectures, naturally develops a respect for the people who scrutinize these architectures, who oversee compliance with the rules of data protection, that most complicated science, and for these people's authority." Does anybody recognize the quote? This is like, it's actually a famous quote that's used in personal data protection land. It's from Solzhenitsyn, where he says, like, everyone is guilty of something or something to conceal, and then each man permanently aware of his own invisible threats naturally develops a respect for the people who manipulate the threats, who manage personnel records administration, that most complicated science, and for these people's authority. So I think what the GDPR has done, it's like really given like the other side, like this possibility of scrutinizing these systems. And that partly has to do with these very open rules about which you can disagree on their interpretation. So you can go into that system of scrutiny with very strong interpretations of what it means to comply with data protection rules. And you see a lot of that, especially happening from like individuals and civil society. So one area where you see this a lot is in the use of data access rights and data subject rights more generally. So they're an increasingly popular instrument. You see that, like, well, so you're allowed to access, request access to your personal data and ask for information about its processing. You see researchers, academics using that, but also journalists are using it, privacy advocates. The interesting thing, of course, is, and the strength is like these data access rights, they're basic and they're also fundamental. They're in the fundamental right to the protection of personal data. And they're very powerful as they leverage this broad scope of the concept of personal data. So evidence, when you start using these rights, continues to show very low levels of compliance. So often you're not getting what you're supposed to get. But use of access rights has been shown to be very interesting, and it's also on the basis of the Max Schrems campaigns and reporting on Cambridge Analytica, use of data access rights was very instrumental there as well. So this is another area where there's a current campaign coming out of civil society. There's this new organization called None of Your Business. This is a new privacy organization founded by Max Schrems. It launched a number of cases on GDPR Day, like 25th of May, against major service providers, including Facebook, Google, WhatsApp, and Instagram. The last two, of course, also being owned by Facebook. And one of the key questions there, what personal data processing can be considered necessary for the offering of the service? And so he is like doing this litigation on the header of forced consent. So I think this, from a pet's perspective, already very interesting, because you have a service and it's built, let's say, in a quite privacy-unfriendly way, and you could say, well, that's not necessary at all to process this personal data or this personal data, because you could have applied this technique and this technique. So it's really that question of like, how far do you need to go with implementing existing technologies that can help you to be less personal data processing intensive. But it's also on this rule of building of personal data processing, the bundling of personal data processing with acceptance of the service. It's not allowed when it's not necessary for the service. So that's a rule that, like I just mentioned. But of course, like, that's kind of circular. It's like that doesn't really answer the question when things are necessary for the service. So, and there you can go in still quite radical different ways. One of them is to say, well, the service provider decides what is necessary for the service by designing the service. You know, that's one option. I think from a US kind of legal perspective, that would definitely be, that's how it works. You know, it's up to the service provider how it works and how it's designed. But you can actually take a completely like opposite kind of radical route that says, well, you have to actually deploy an objective standard of what is necessary, considering the fundamental rights at stake, and then the user should be able to have a choice how personal data intensive the service is that it ends up enjoying. Now, so you have to kind of unbundle the service in a way that, like, there's a version of the service that is not personal data intensive. So this case is likely to move up the legal chain, potentially to the Court of Justice of the EU. So a few coffee cup reading perspectives on pets and the GDPR. How much time do I have left? 4 minutes. I can take a few. So it's hot here, actually. So like I said, there's no clear mandate to implement specific privacy-enhancing technologies. So at least really quite open what particular measures you should be taking. So it's like there's really not much of an answer there. So I think that means that there's a lot of space for showing what you could be doing. The pseudonymization part is definitely mentioned. So anybody that like works on pseudonymization, they can be very happy because like that is something that like will get a lot of interest. So then on this risk-based approach, I think that very clearly invites development and implementation of a specific type of PETs that address particular types of risks that are identified in data protection impact assessment. So that's very interesting, no? And not only data privacy risks, but actually quite broadly also other risks to the rights and freedom of individuals. So when you're working on like risks of personal data processing systems, you can include all sorts of risks, including risks of discrimination, for instance. I think there is then, on the implementation, there is a bit of a control paradox, that it may be true that the best way to comply with GDPR is to have centralized personal information flow architectures. Because really that gives you this overview and it gives you the possibility to make yourself accountable for what's happening. It gives you the best way also to respond to people who want access to their data and want you to do things with their data. So that's, I think, a kind of a push towards centralization, apart from the one that you maybe already have, by just the fact that it's really quite cost intensive and hard to comply with. There's no clarity really what is exactly expected, and so there are a lot of inherent tensions and conflicting perspectives in the GDPR. So I think, like what I said, the question is really what the controller wants to do. What is the kind of privacy proposition you want to make towards your users or people affected? But most controllers do not really make these actual data privacy governance decisions, especially not the technical ones. So there you see it's really important to see that it's about this conversation between designers and producers of technical systems and the people that end up really enjoying their functionality, which involves the processing of personal data. And it's that conversation where I think a lot of the action is. So then, like one thing that I think is important that relates a little bit to the paper, the last paper of the first session, there's really a need, I think, for further development of data privacy technologies that protect people against new forms of data-intensive organizational power. So there is this right against automated decision making, but there you see the protection that policy people really triggered by is like, so you have automated decision making, what is the protection? It's a human in the loop. You know, and I think this is it's kind of a knee-jerk type of reaction of what is the appropriate way to protect people. And I think there's a lot of potential to think about new types of technologies that can be developed to protect people's interests in those contexts. So on compliance, yeah, that I'm very sorry about, but if you take it seriously, compliance can be quite costly. And I think it's especially costly if you do compliance exercises on information systems that have been kind of built from scratch, from the bottom up, in a kind of unique way, doing things with personal data. If you have decentralization in your system and certain forms of encryption, that I think can create a bit of a controllership vacuum. And that is in tension of what is expected on the basis of the GDPR in view of information accountability and data subject rights. So you can actually, by implementing certain types of decentralization or encryption technologies, you can lose the control that maybe the legal framework assumes that you should have. And then in combination with the fact that you have this broad concept of controller, I think it's possible that even though you have decentralized things and you do not really have control or access to the data, you suddenly may be considered like a controller, and you cannot ensure compliance with these rights. So you can end up a little bit in a catch-22 situation. So then finally on the enforcement, I think very clearly there's a lot of technical expertise needed in privacy policy and enforcement discussions. There's a big role to play for the community in the detection of data privacy issues in personal data architectures. The documentation of like what are the types of risks of systems and ways to address them. So what I said about the data protection impact assessment, you know, looking at particular types of risks and how they can be addressed, that is a really clear area of work. But on a more conceptual level, giving explanations of what forms of data privacy, particular technologies and organizational measures can help to protect. You know, what are the properties of particular types of measures? Because the space in the law and policy is so open, you know, what is actually being offered if you say you throw a bunch of privacy technology into a system, what does it really help to achieve? That exercise I think is very important, and PETs community input would be very helpful on that. And then finally, research feeding into data protection policy and GDPR enforcement. So being in touch, of course, with regulatory authorities, but also I think increasingly what it would be interesting for researchers to collaborate with civil society organizations that are involved in some of those strategic litigation campaigns. With that, I will finish because I'm a bit over time. Here are my conclusions, but they're just summary. Thank you very much.
In fact, we still have a few minutes for questions.
Hi, so I've been trying to figure this out myself. We see a practice in a lot of data controllers, service providers, where they exclude people using certain privacy-enhancing technologies from using those services, whether that be Tor users or whether that be people that have extensions that block trackers and things like that. Do you think the GDPR has anything to say about whether that sort of practice is legal and under what circumstances it might be?
That's a great question. So I don't think that GDPR has I don't think they have, they definitely don't have a rule on that, for instance, that you're not allowed to block people. So they have this rule that is looks a little bit like protecting people against this kind of tracking wall type of situation, or like the situation was brought up with apps. But even there, it's very ambivalent. And I think, to be honest, there's just not there's not a lot of support in the law for the use of those more strictly offering confidentiality type of protections to people. That's actually, I think, also why that is a domain where the technical work is so important, to offering the possibility to have these properties, because the law is not really offering them. So the question of whether it's allowed to, I think we would have already seen more litigation if it was really possible to complain about the fact that you're, for instance, not able to use an online service if you're using Tor. It's not. I don't think there are that many kind of legal. You don't have that much leverage in the law to fight against that. But that's the situation. To say that the law is hostile against those technologies would go too far. But it's definitely not trying to say everybody should be allowed to use this. And it's a bit a similar situation as the way that GDPR relates to obfuscation. When you do obfuscation, of course, that goes totally against the logic of the system. It's like with obfuscation, you probably end up putting all sorts of wrong personal data in the system, where the idea is actually you're going to make it work. You're going to make all the data that is in the system, you're going to make it correct and give people rights to ask, look at the data is correct. So it's really a different paradigm of protection.
Thank you for the talk. I had a question in reference to your presentation. Could you shed some light on the recent lawsuit against Facebook and Google by the EU? Could you shed some light in context of your presentation on the recent lawsuit against Google and Facebook?
On what against Google and Facebook?
The lawsuit against Google and Facebook.
Yeah. So I mentioned I put this. I think the lawsuit. This is I've been mostly looking at the lawsuit against Facebook on this. So because of this new obligation for controllers to say what is their legal basis, you see now in the privacy policies, you see what legal basis services are relying on, and Facebook, in a I think little bit risky choice strategically, they really put most of their money on this necessary for the service. So including, I think, the tracking they do with respect to you as a Facebook users on third-party websites and all sorts of things. A lot of it is actually bundled and say this is all necessary for what we do, and that includes, of course, necessary because their reasoning is we are offering this stuff for free, and we want to make it very widely available to everybody without having to pay. So that's their reasoning. But I think it's a risky strategy for Facebook. First of all, legally speaking, because it's quite easy to find something that that should not be you should not be allowed to bundle that with the acceptance of using the service. But secondly, also because they are obviously the first candidate for being under scrutiny, by both by civil society but also by regulators. So the regulators already created a social media group. I mean, this is it's a very clear target in the media. So the scrutiny that they're getting on that is very predictable. And so it's I have a sense that could end up badly for them, that strategy. But of course, then the question is they can still correct it, of course. So there's other litigation also coming out of France, and I mean this is we will have to see what exactly comes out of that. It's very hard to make specific predictions, but I think with what I said also about the strength of the rulings of the Court of Justice of the EU, it's very likely that quite some of that litigation will have some outcome that will have to lead to adjustment in industries, changing some of the practices.
Yeah, thank you for your talk. So I just want to point out one point. I'm sure you're aware of this, but for the rest of the audience, where there is support for pets in the GDPR, Article 25 talks about taking into account the state of the art. So the question then becomes, from a regulator perspective, is are they going to consider state of the art the academic state of the art and the kind of privacy community state of the art, or the general tech community, which doesn't have access to computer science PhDs who are doing differential privacy and all of those kinds of things? So which one is the regulator going to accept? The other thing I just wanted to point out, I think you're absolutely right on the two options. When I talk to companies all the time, I always point out that second option, and going back to some work by some people here, Carmela, Claudia, and Seda, on engineering privacy, about setting a goal and then looking what is to reach that kind of high-level goal, what is the minimal amount of data that you can reach that high-level goal. Because I go into companies all the time and they're like, oh, we're trying to do this, and then I start digging deeper and no, we're really trying to build a surveillance system, and end up, and we really want to collect a whole bunch of data. We're not trying to do something that's privacy preserving. So I think that's a very critical point.
Yeah. Great, thanks.
I was wondering how the GDPR looks at technologies like multi-party computation or homomorphic encryption, where basically organizations can say we don't have the data, and therefore we don't need to be compliant with GDPR.
Yeah, so that goes this is something that has struck me a lot in looking at some of the technological measures that are taking in industry context also, where one thing I looked at is Facebook, they're partnering up with this data broker that has all this information about sales in stores and brick and mortar stores, real world stores. And so they partner up with this data broker and they implement some kind of privacy technology scheme, that allows them to then measure how advertising at the individual level on Facebook are driving sales at the individual level in stores. So this partnering up allows them to do this kind of measurement, which that would be exactly the kind of thing you want to achieve if you combine the data sets. But then they're saying we're not going to exchange any PII, PII. We're not going to exchange any personal data. So that is, I think, the question is it GDPR, is this really about preventing personal data from flowing, or is regulating personal data processing a proxy for trying to achieve something else, for trying to achieve conditions of privacy? I think it's the second thing, and this personal data is just a proxy to regulate something or to give certain safeguards. But if you have this narrow idea of it's actually about personal data processing and try to prevent that, you can forget that you end up implementing technologies that are doing something for privacy. They are doing something, but it's actually quite limited. And it's actually not protect against the thing that is actually combining the informational power that is in these separate databases, and also would it's like achieving exactly nothing in terms of like the combination of that or data-driven power. And I think that is somewhat worrying. Now, it's also somewhat worrying that it allows you to really, like the GDPR allows you to say, we are doing all this great stuff. We have this very advanced like privacy technologies, implemented in all sorts of like local parts of the information system and all sorts of interfaces that we have, but not like require organizations to have like the bigger picture kind of answer about what is actually this proposition towards individuals in terms of their rights and freedoms. Thanks.
Yeah, so I mean, I think what my question has always been, what really is the point of the rights and freedom that the GDPR environment protects? So of course, I'm very sympathetic to any set of laws passed by any nation state, but Europe seems ahead of the game here, protecting human rights around privacy and data protection. That's clearly important. However, in execution, you speak into the mic. Okay, in execution, but in execution, I feel like the GDPR actually is mostly about restricting commercial transborder data flows, and the reason is because the GDPR has a giant loophole in it, which you did note briefly, which it does not apply due to national security exception derogations to nation-state level intelligence agencies and law enforcement. So to my knowledge, I'm running 2 court cases on this, is that effectively, if you do believe that you have some personal data held in a public body, particularly an intelligence agency, you have essentially no data protection rights, no right to correction, no right to be forgotten, and that's, I think, actually really dangerous. And if you look at it, that's why, for example, even though you had data protection regulations in the UK in 2011 and 13, effectively, when the NSA had to do some dirty work, they were to ask GCHQ to do it. Because again, all these wonderful laws only apply to commercial companies. And that's, I think, a very dangerous presumption then. It's very dangerous to assume that this actually defends human rights. And when you say, well, if it only applies to commercial companies, then it actually, the GDPR seems to look more and more like essentially a Europe to do some fining of Facebook and some essentially trade protections, which I'm okay with as well, but that doesn't have too much to do with actual real-world privacy or human rights. Now, the only thing you mentioned, which I would love some more explanation on, is apparently the police data protection regulations, which I have not seen very much, if nothing, on, and are not currently enforced, even if they ever will be.
Yeah, so just to quickly start on the last one, which is probably easiest to answer. So you have specific frameworks, regulatory frameworks in the member states for what police are allowed to do with personal data. Once they have collected, are they allowed to share it, what they're allowed to do with it. So this police data directive is a directive that harmonizes this across Europe. There's still a lot of flexibility in it, but it's kind of like it just says this is for all police, law enforcement, personal data processing in Europe. And then on that basis, it also sets the conditions for law enforcement to share personal data between different national law enforcement agencies. Because if you have different laws, then it's going to be like, are you allowed to share it? And they are going to like the Germans are allowed to do so much more with the data, so then the Dutch, they're not willing to share it. You're going to end up in this situation. So it's a harmonization exercise. On intelligence, I mentioned also the international standard, the Council of Europe Convention, and also Article 8 of the European Convention of Human Rights is also applicable to government data processing in the intelligence context. So that's an important final safeguard, and you see quite some of the litigation also after the Snowden revelations, and also in the UK, the Big Brother Watch and Privacy International and other case about national security surveillance. That is happening within the boundary of Article 8, and a lot of like case law about like what is allowed with national security surveillance. So there is still some law there, but it's true that in many ways, and I think it's a very similar situation. It's like we have this research about like what is happening on Facebook, you know, and Facebook giving all sorts of controls and policies that give people the idea that they have control over their personal data, and that like incentivizes people to share more, you know. And so of course the GDPR is also there, and one of its explicit goals is actually to give people trust in an information society where personal data is flowing very freely and pervasively. That is one of the goals of the law. It's actually, so in many ways it normalizes the situation where our personal data is flowing all over the place and being used to power services, to power all sorts of functionality and organizational practices. And I think you were hinting at that in some other ways, and that's completely right.
So I wanted to have your opinion, but it seems that the notion of pseudonymous data is quite dangerous because pseudonymization is very weak in terms of privacy guarantee, and a lot of companies might be tempted to just go for that and instead of doing more. So I wonder what you think about the introduction of this concept.
Yeah, so I think, I think you're right. So the point was like, what do you think about the pseudonymization? This is actually, from a privacy perspective, it's quite a weak measure. And is this not then just very easy, like you just do a bunch of pseudonymization and then you're complying with the law already? And I think, yeah, that's true. I think that is a problem. The situation in the debates, like in the legal debate, like the political debates about what the law should be, there was really a design for a GDPR that had GDPR light for pseudonymous data. You know, you basically, you could, like, you didn't really need like much of a legal basis anymore. You had much less transparency obligations. There was really a light regime for pseudonymous data set up, but it didn't make it into the actual final text. The final text is very clear that it helps you to achieve compliance, but it doesn't change the rules that apply to you. So in some ways, the situation is much better than it could have been, and I think that was really what was pushed for. The struggle, like I'm really struggling with this also from, let's say, more a conceptual perspective, what it really means to pseudonymous data and why is that really a meaningful thing to do. You know, because it's really about this thing of de-identification, and like the identifiers we have in our society, they're quite contingent on like particular kind of information architectures. A lot of them are quite outdated, you know, like so on policymakers, it's like, what are identifiers? You know, they're gonna be like, well, that's a name, and it's like maybe your address of your house, you know, or like a telephone number. But there are so many other identifiers or combinations of information that are actually identifiers. And so it's not exactly clear, like what is your starting point of that exercise of pseudonymization and like the identification of data. You know, so this is something I'm actually struggling with. What is actually happening there? You know, what are you actually trying to achieve especially in a digital environment where we have so many new forms of identifiers and we have so many ways in which information systems can play with these things. So, I mean, you're probably better able to answer the question of how sensible it is to do something of pseudonymization, also in respect to a particular system and a particular. But I think that's what's needed. That's what it's really needed to explain what are you actually achieving here and what are you achieving for people.
So 2 questions. The first one, is it possible that we'll have a paradoxical result that small data controllers will say, I'm not privacy preserving, privacy protection because I'm screwed anyway. It's impossible for a small organization to do it right, so why bother? So that's the first question, is whether they'll just ignore everything on the assumption that you can't get it right anyway. And then the second question is, again, predict, please, 5 to 10 years from now, how are we going to look at GDPR? What's the impact going to be? Are we going to say it's a success or a failure? And how will it change things? Thank you.
Okay, great question. So the first question is, what to think about the possibility that small data controllers, you know, maybe not have the knowledge and capacity. They're just like really like I'm not going to do this at all. So like we have to look at it from, I think, from the starting point situation is that nobody was doing much at all. No, so there was not much compliance with the Data Protection Directive. And the GDPR creates a situation where there's much more compliance. So I mean, I would say the glass is half full there still. It still achieves something, and it also achieves something, especially with respect to the entities that do the most and have the most kind of, like the most influence in privacy governance land. So, and I think, yeah, I mean, and I don't think I'm not so interested in those much smaller organizations. I think the problem, of course, is they could be targeted in ways that are not fair. Like it could be that regulators suddenly go after a particular sector, or like in ways that are problematic, or it could be you can use it against your competitors. You launch a data subject access campaign against one of your competitors. But you can do things with it that are potentially problematic. So that's really that's then at the level of enforcement. And finding also, I think then the second question is like how to evaluate whether the GDPR did something right, let's say in 5 or 10 years. And I think that is very, very difficult question that I'm trying to set up like some work on. Is like what are actually the right standards to evaluate this? Because this is such a broad, sweeping framework which also has quite a vague norm. And so like of course you can look at it in terms of compliance, and you can start like tracking that, but really for evaluating whether it does a good job, and also on the more specific question of the resources that are put into both organizing for compliance and then also evaluating that, it's like, are they well spent? That is a very, very difficult question because you can go so many different ways, and it's very easy to, I think, to see like my intuition, there's going to be a lot of paperwork, there's going to be a lot of box ticking, and it's not going to be that meaningful, So the question of how meaningful the things that the GDPR is going to achieve they are hard questions. So we need to find ways to evaluate that and prepare for that evaluation. That allows us also then to say this needs to be tweaked and this needs to be improved and this needs to be changed a bit. Yeah.
Yeah. So just to add to this comment on pseudonymization, because earlier you talked about sensitive data, and you said that sensitive data means data that can reveal some sensitive attributes. But is this defined in the GDPR? What sensitive attributes or that sensitive term really means?
So, sorry,
what does it mean for data to be
whether
sensitive?
It's defined?
Yeah.
So it's defined in the GDPR defines those particular attributes. So ethnicity, race, sexual orientation, religious beliefs, they're put in there. So that's clarified. But the question of what information reveals that and like what is the standard, it's really, really messed up. I have a master's student finishing with a thesis. She just sent it to me. And like she looked into the standards and it's an utter mess. And you see like all the regulators like moving around with their interpretations of what it really means for things to be sensitive data. And one of the reasons they had to do that is because of our visual culture and everything being pictures. And if you have pictures, like they reveal a lot of those things, potentially also. Because it's one thing to say with 100% certainty you can tell from the data that this is the case, but that is of course not the right standard, especially when like a lot of data systems are about making certain types of predictions with a certain amount of certainty. So I mean your location data is probably is health data, like your pictures are this. So then you see the regulators kind of moving their interpretations around, and they say, well, like if it's not like if you don't really have an intent to know what these sensitive attributes are from by processing it, then you're not under those rules. But but then in other situations they're very strict. They say, well, this could even be potentially revealing of this, and then so that's are the regulators, and then you have court cases at the lower level and at the higher level making a very, very mixed picture. And this is something that it actually was known already in the 70s that this was probably a much too simple way to think about this problem of sensitiveness, you know, in personal data land. And now it's still in the GDPR. There's a court case in the right to be forgotten context. Google was confronted with requests that have to do with removal of data about criminal convictions. And this is one form also of sensitive data. And so the Court of Justice, they have to make a ruling on what is the scope of that and how much of an exception is possible with those rules on sensitive data. So there's, and there will probably be a lot more to come on that.
So, about the role of the processor in the context of the web. So this is a very complex and dynamic given website. Can you hear me?
No, you're switching off sometime, but I think the other microphone seems to be working quite well.
Maybe some radio issues. Yeah.
Can you, maybe the other?
So, I was asking that, I'm curious about the role of the processor in the context of the web, because this is a very complex and dynamic ecosystem in which you have multiple players. Like, for instance, a given website may have a given ad network, and that network may actually leak data or share data with another service because of all the ad mediation ecosystem. So, how can this specific website actually list all those processors of data that are actually going to show up in a very dynamic way? How does actually the GDPR try to prevent or control that kind of personal data dissemination?
So you're talking about the situation in which, let's say, a website has integrated a bunch of like tracker functionality and things like advertising networks, and is that the situation that you're trying to?
Yeah, it's like, for instance, your website has DoubleClick.
Yeah.
And then DoubleClick dynamically loads some content from another partner player, like for instance Criteo, right? Which is something that is a consequence of the ad mediation and the bidding happening in the web. So how does actually the website need to know that Criteo will actually collect some personal from the user?
Yeah. Well, I mean, I'm not going to answer, like, I'm not going to give the legal answer to this very specific situations because it's quite hard, but I'm going to say a few more general things about it. So first, there's a case there is about integration of Facebook like buttons on, the Court of Justice has to decide that pretty soon. It's a bit similar case as the Wirtschaftszimmer case that I described, and it's really about the question, in what situations are you a controller? So if you integrate third-party type of personal data processing things, or you just put a pixel, but it leads to personal data processing, the question, of course, is as the original website, what is your responsibility for what those other entities are doing with personal data? You know, and there you could say, well, they just have their own responsibility. But what you see happening now is that also the first party is made responsible for what the third parties are doing with their personal data. So they already have to negotiate then on whether that's legal or not. So this is something you see it also, you saw this dynamic played out openly in legal discussions between the publishers and Google, where the publishers were asked to ask for consent for what Google is doing, you know, and the functionality Google is offering them. So you can see a little bit of like GDPR debate on that. But I think the problem is really that it's not that clear who is a controller and who is a processor. You know, like you can easily also move out of the processor concept if you start doing things with the data yourself. You know, and which is often, of course, the case. It's like maybe you're offering some functionality, but then by wanting to improve that functionality, and you want to use the data that you have from all the different customers that are using your functionality. You want to learn from that and improve, and then you become a controller as well. You know, and then and it's like the situation, technically speaking, is so complex and networked. That the data protection is quite struggling with finding the right ways of attributing the responsibility, let alone apply the rules. So this is it's really at the basic level, you know, of like who is even responsible, that we have very, very hard questions that we're still grappling with. You know, like that's why I said also there's still quite a lot of legal uncertainty, you know, about these situations. So, I mean, it's just like, then in the end, the question is, like, of course, like you can make some kind of agreement between those entities. This is going to be your responsibility, this is going to be mine. So that's something you saw between Google and the publishers. And that's, like, then the question is, can that withstand scrutiny? You know, and like there, like you can imagine that it can, but like to make that kind of initial determination is quite a lot of work. And it requires a lot of coordination that maybe doesn't even exist. No? So it's complicated.
Okay, it is always a pleasure to have scholars from communities that are related to privacy but are not technical speaking to us. Actually, as punishment, we will make our speakers sign a consent form to use the video, which is relating to data protection. But I would like to thank Joris again for a very interesting introduction and all the things.
Thanks everyone.